you so much, everybody, for joining us today for our topic with guest speaker Conrad Grant on landlord tenant law. In just a second, I'm going to turn the webinar over to Conrad, but I'm going to take just a few minutes to tell you guys about Advanta and what we do. My name is Larissa Green. I'm with Advanta IRA. I've been with the company now for just about 7 years, and I do education, marketing, and sales. And I've been doing presentations for probably about 5 years, and we teach on all kinds of topics here at Advanta concerning self-directed IRAs. And we also bring guests like Conrad on to talk about things that we know are important to you as investors for anything from landlord tenant law all the way through how to use the system for bidding on tax liens and deeds with counties that are local to our offices. So we have education going on all the time. We have 2 offices, one in Largo, the Tampa Bay area of Florida, and also in Atlanta, Georgia. But we have clients nationwide and even worldwide, and we try to offer everybody the same personalized service they would get if they could come to one of our local offices and sit down with us. So everybody that is a client of Advanta IRA does have an account manager, and they work with that person directly for the life of the account. As I mentioned, we also have educational programs going on all the time. They're always no cost, no obligation. And if you're interested in learning more or visiting our YouTube channel, you'll find all of our webinars are archived there. So you can go and visit those for any topic from private lending to investing in cryptocurrency. Advanta does not give any tax, legal, or investment advice. So if you have questions on the rules and whether or not the investments you're planning on making or the strategy you'd like to use is something you can do in an IRA that we can help you with. If it's something we can't help you with, though, go ahead and ask your questions anyways. And if we can't, then we'll direct you to somebody like Conrad who can answer your legal questions or a tax advisor or what have you. So go ahead and let us know if you have questions. Also, I want to mention that we're going to take questions throughout the presentation. So if you have questions, again, we're going to keep it muted, but please go ahead and type your questions into the chat box, and we'll get to those as we go through the presentation. Advanta IRA does hold IRA accounts. Pretty much any qualified plan can be self-directed. If it ends in IRA, it can be self-directed. So the most common types of accounts that we see, of course, are going to be traditional and Roth IRAs. But we can also help you with simple IRAs, SEP IRAs, and individual 401k plans. If you have an old employer plan, an old 401k, 403b, some pension plans also, those can be self-directed as well. I also have up here on the list education savings account and health savings accounts. And although those are not retirement plans, the rules for self-directing those types of accounts are the same. So you can also invest those types of accounts into real estate, cryptocurrency, tax liens, private lending, gold and silver bars, any of those things that are outside of the market we can help you with, and we can help you with those types of accounts. I'm not going to really talk much today on this presentation. I just want to give you an idea of what we can help you with before I turn the presentation over to Conrad. But for real estate, for the purposes of this presentation, I just want to let you know that pretty much real estate in any form can be invested in through an IRA. And because Advanta IRA has nothing to sell you at all, you as the investor would bring the investment to us, and we just help you get it properly named titled in the name of the IRA, and then we do the record keeping for you. And so that would be receiving income, paying expenses, and doing your IRS reporting on behalf of that IRA account. And since we don't have any investments to sell you, you would go out there, find the investment that you wanted to make, let us know what it is, and we help you get it purchased through the IRA. And so today we're going to talk specifically about real estate. And so real estate that we see here at Advanta is commercial real estate, residential real estate of any kind. So whether that be a rehab, something you're purchasing just for the purpose of fixing it up and turning it around and selling it, something that you can certainly do. Or if you like to invest in long-term investments, a long-term hold property like condos, duplexes, single-family homes, multifamily homes, any of those things are acceptable in an IRA, and we can help you with all of those. And just to give you an idea quickly of how that works, I'm going to give you an example through a case study, something that we see very typically here at Advanta IRA. So purchasing real estate in the name of the IRA is very easy. If you've purchased rental real estate or investment property before, then you're pretty much already familiar with the process involved. But the biggest difference is the funds are going to come directly from the retirement account, and the title is going to be held by the retirement account. So in our example here, Susan has $120,000 in an old 401k that she wants to use to buy real estate. Again, because we have no investments to sell you at all, Susan's going to find the property that she wants to invest in, and whether she's working by herself or with a real estate agent, they're going to negotiate the price of that property and then basically come to Advanta with the contract when they're ready to make that purchase. And everything from the contract all the way through the closing documents are going to be in the name of the IRA account. We can help you with that. And on this property that she finds, she's going to determine that it needs some repairs. Again, all of this is determined by the account holder. And the repairs do have to be paid by the IRA, so she's going to make sure that the purchase she's making allows for the room she's going to need in order to make those repairs. And then once it's rented, Susan estimates that she'll receive $1,000 a month in rental income. So what does that look like? Well, Susan's going to open an IRA account with Advanta. We do hold the account for you. She's going to fund it either through moving funds, in this case, from her 401k or from an IRA. She found the investment, made an offer to purchase, and after she agrees to terms for that contract, she's going to complete a purchase authorization form with Advanta so that we just very simply know who she's working with, the property she's buying, and anybody involved in this transaction. So closing attorneys, title agents, whoever it might be that are included in the process for the purchase itself. Once Susan has read and approved all of the documents, we actually are the legal signer on behalf of her IRA, so we're going to go ahead and sign those documents, and then we'll fund that transaction directly from her IRA to whoever is working with her on the purchase. So just a couple of things again to mention is that the IRA itself is purchasing the real estate. This isn't a loan from the IRA. Instead of holding stock, Susan is simply holding a deed for the real estate in her IRA retirement account. She negotiated the price, and she's going to determine what she's going to do with that property. The deed is in the name of the IRA, and I have a sample of that here, Advanta IRA, for benefit of Susan Smith and her IRA account. If she wants to leave her name off of the deed, she can do that and just use her IRA account number for some anonymity there. And then the IRA pays the expenses, receives the income, and Advanta also does your IRS reporting. So we do all of that on behalf of the IRA. And Susan's just going to let us know what needs to be paid. So she'll let us know what vendors she's going to be working with, either general contractors or vendors, a handyman. She'll submit the invoices over to us. We'll write the checks. And then once the property is rented, her tenant will send the checks directly to Advanta, and we'll deposit those on behalf of her IRA account. And so now I'd like to introduce everybody to Conrad Grant. He's an attorney, and he's going to be speaking about landlord tenant law. And I actually met Conrad when we were networking at an expo for the National Association of Residential Property Managers. So with that, Conrad, I'd like to turn it over to you. How are you doing today?
Thank you, Larissa. I'm doing fine, and I appreciate you setting this up. And let's get started. We'll take questions. Larissa will chime in. I'll ask if there are any questions, and please use the chat box or message box, and she will be happy to present any questions to me. All right? Going to get started. So my name is Conrad Grant. I'm one of the partners at the law firm of Kelly & Grant. And today I'm going to talk to you about landlord tenant law. This is typically a 3-hour course that we do, and it's usually done for credits, but I have distilled this into a good 45-minute chunk to give you the best information. So you're going to learn a lot. Keep in mind that I am a Florida attorney, and this is going to be based on Florida law. So will some of the principles be applicable to other states? Yes, they will be, and it might just give you enough information to go contact an attorney in your state and ask the right questions. But just keep in mind that this is based on Florida law. I don't know any other law outside of Florida for landlord tenants. All right, moving on. So we're going to start off. We're going to talk about basic landlord tenant. We're going to start off with squatters, forcible entry, unlawful detainers, motions for writ of possession, and then tenancies in general, how to terminate them, the eviction process, and also how to deal with security deposits. So what is an unlawful detainer? Well, an unlawful detainer, I need to touch on this so when you see it, you know that it's not a landlord-tenant matter. Landlord-tenant matters are handled under Chapter 83 of Florida statutes. Unlawful detainers are Chapter 82. So it is used for squatters and unwanted guests. You have three important elements. So when a client calls me, I'll ask these three questions. Do you have a legal right to possession of the property? Have you asked these people to leave, and have they refused to leave? I'll then follow up with, are these people tenants? They'll say no, and at that point I'll say, did they ever used to pay rent? And if the answer is yes, then at that point I'm going to tell them that it's a landlord-tenant matter and that it is not an unlawful detainer matter. So we typically serve a 5-day notice to vacate. It's not a statutory notice. It's not required by law, unlike landlord-tenant, which has certain statutory notices. This is just something that we need to show to the court that this is, we ask the person to leave. So we use that to satisfy the element that they refuse to leave. It's the same summary procedure as evictions. And what is summary procedure? Well, if you think about normal lawsuits, if you've ever been involved in a lawsuit or in foreclosure lawsuits, they can take forever. They take months. They take years. Florida law states that certain cases, like landlord-tenant matters, fall under summary procedure, which means the time is shortened and the court has to expedite all these cases. So, for example, when you serve someone with a summons, it is usually 20-day notice or 30 days notice. In landlord-tenant or unlawful detainer, it is going to be a 5-day notice. All right? So it is summary procedure. So when you unlawful detainer, just if there's no tenancy involved, then that's when you're going to use that. Someone who breaks into a property, a guest who overstayed his or her welcome. The next is motions for writs of possession. And this is for you brave souls who decide that you're going to buy properties at county auction. So this property is typically being foreclosed on, and you'll need to remove that person from the property. If it's a squatter, then we can use unlawful detainer, but why use that when we can use a motion for writ of possession? And if it's a former owner, you need to use a motion for writ of possession. So the first thing I'll do when someone comes to me and say, I bought this property at county auction and someone's living in the property, I'll try to determine whether it's a former owner or if it's a valid tenant. Still, it doesn't matter. What I need, though, is the certificate of title to be issued by the clerk, and then we need to serve a notice to vacate. And this notice to vacate is outlined in Chapter 83.561, which says that if a person was living in the property when it was foreclosed on, you have to give them 30 days. After the 30 days expire, we file a motion for writ of possession, and what we're basically doing is reopening the foreclosure case and asking the judge to remove all the people that are still living inside. The cost of a writ of possession is $90 in most counties and $115 in Miami-Dade County. So this is strictly for auction properties. Any questions on those two before I move on?
We did have somebody ask about the 3-day notice, but I think you're going to touch on that.
Yes, I haven't gotten there yet. I was just telling you about two other methods of removing persons from property, and that was unlawful detainer and motions for writ of possession. Now we're going to talk about tenancies, properly terminating tenancies. Someone said they can see the slides but cannot hear anything. I would advise you to follow the instructions. where it says you need to call in. There's a phone number and a passcode. Okay, so terminating tenancies. Now this is why you're here, terminate tenancies. So you need to post a 3-day notice. If it's for non-payment of rent, let's start off with non-payment of rent. Why? Because this is the most common type of eviction in Florida. So the first thing you have to do is post a 3-day notice. Now here are the rules for posting 3-day notices. If you're using a P.O. box as a landlord's address, then you need to add 5 additional days. If the tenant pays the rent in full, you have to accept it. Why? Because the 3-day notice says pay rent or leave. If they pay you the rent, you have to, by law, take that rent, even if you don't like the tenant. You cannot give an early notice. So if rent is due on the 1st and there's a grace period until the 5th, you cannot post that notice prior to the 5th. You have to post it on the 6th. So pay attention to that. Do not include late charges or utilities. You can only include rent. Do not include the day the notice was posted in your 3 days, and do not include weekends or court holidays. Avoid mailing. If you mail it, you're going to have to give 5 additional days. And I'll show you how those 5 additional days can add up. If it's a Section 8 case, then you need to send a copy of whatever you're filing, your notices and anything you're filing, to the housing authority. That's just one of the rules if it's Section 8. So I typically show this as a joke. After all that, is this a proper 3-day notice? No, it's missing a lot of elements. What about this one? And this, I didn't make this up. These are notices that we've gotten from novice landlords. And sometimes they take these to court. They file an eviction against their tenants and they take these to court. So that's not valid. This is what's valid. This is plucked directly from the statute. It's written almost word for word in the statute. If you take a look at the top right, you'll see this is the date the notice was delivered. You'll address it to the tenant and all others in possession, the property address, the apartment, the city, and the state, and the zip. Here's the body of it. You are hereby notified you are indebted to me in the sum of $1,000 for the rent and use of the premises located at, and you add the address, the apartment, the city, the state, the zip, the county. If you're missing any of those blank spaces, your notice is defective. Moving on. Now, occupied by you, and I demand payment of the rent or possession of the premises within 3 days, excluding Saturdays, Sundays, and legal holidays, from the date of the delivery of this notice, specifically on or before, and you calculate your 3 days, and that needs to be accurate. And I'll show you how to do that in a minute. Then you have your certificate of service, and this is your proof to the court that you actually served this on the tenant. And you can check off you delivered to the tenant. That's personal delivery. Posting in a conspicuous place on the premises. This is if you attempted to deliver it and the tenant was not at the property. You can tape it up on the door, somewhere conspicuous. Notice I did not add mailing because I want people to avoid mailing. Unless your lease says you have to mail, you should avoid it because you're going to lose a lot of time, and I'll show you why. Then you need the landlord's name or the landlord's agent. So if you are a property manager, you could put the property management company, or if you work for the landlord, you could put your name, the address, and phone number. Every single blank line is required by statute. Do not miss anything on this 3-day notice. A lot of cases are won and lost by 3-day notices. Why? Because it's a prerequisite. If a 3-day notice is not proper, your lawsuit is not proper, and then the case can be dismissed by the judge. So it needs to be accurate. So I'm not going to, before I take any questions, let me show you. This might answer some of your questions here. So here is a calendar. This is how it would look with a normal 3-day notice. So we get that 3-day notice. We serve it on the 11th. Day 1, day 2, day 3, So you notice we have to skip weekends and holidays, and the 17th we could file the complaint. So this is normal. Let's back it up. If we serve that notice on the 10th, we could file this eviction on Friday. So you notice the day the notice is served is not counted. Then you have day one is the 12th, the 13th, the 14th. So that's your standard 3-day notice with no complications. Now, same scenario, but this landlord either mailed the notice or used a P.O. box. So now we need to add 5 additional days. So the third day is on Friday, just like it was before. Now we need to add 5 days, 5 consecutive days. And these days, they're calendar days, but they cannot end on a weekend or holidays. So you have day 4 is the Saturday, and the notice would expire on the 19th, and we could file the complaint on the 20th. So if you compare this to the previous version, complaint was filed on the 17th. Here we file the complaint on the 20th. Not a big loss in time, but it is still a loss. If now we're at the 20th of the month and rent is late, so it is a loss to the landlord. Now here's another scenario. Instead of serving on the 11th, we're going to serve this on the 12th. Day 1 is the Thursday, day 2 is the Friday, and remember the notice said you have to skip Saturdays, Sundays, and legal holidays. So we're skipping Saturday, we're skipping Sunday. Day 3 is the 17th. It's a Monday. So if this was a normal 3-day notice, then we could file that complaint on the 18th. But it isn't. This person added 5 additional days by either using a P.O. box or mailing, and now you can see that the notice will expire on the 24th because, as I said, even when you add those extra 5 days, it can never expire on a weekend or a holiday. So keep this in the back of your mind. No matter what you do, no matter how many days you give, a 3-day notice can never, ever expire on a weekend or a holiday. Okay? Keep that in mind. So here it's a lot of time lost just by adding the 5 additional days. Okay? So here's what you do. Prior to serving your 3-day notice, consult your ledger. And don't just go to the bottom of your ledger and say, all right, this is the amount of money I'm going to put on the 3-day notice. You need to think about it. Because remember that Florida law states that a landlord can only demand actual rent. So actual rent, what if you go to the bottom line in your ledger, but it included utilities and it included repairs or late fees and return checks, and these were not deemed as additional rent, then your notice is defective. So if you're using a standard Florida lease, we call it a FAR bar lease, Florida Bar and Board of Realtors lease, then there is no provision for deeming additional fees as additional rent. Okay? So the example is this, late fees. If rent is late fee of $100 applies on the 5th day of every month. Can you put that on your 3-day notice? Maybe. If your lease states that the $100 late fees shall be considered additional rent, you've now made something that's not rent into rent, and you can add it to your 3-day notice. But if you did not do that, you cannot add it to your 3-day notice. So you need to look to your lease or make sure that your lease is drafted where additional fees, such as utilities and repairs, are deemed additional rent. Because, once again, if your 3-day notice is wrong, your case can get dismissed. Here's an example. Monthly rent is $1,600. Tenant is behind 5 months, and the ledger shows the following entries. January, February, March, April, May, $1,600 each month. And then there's a May late fee. So the total owed is $8,160. I know some of you are thinking this could never happen, but it happens a lot. We get these, these landlords who are too nice, or they listen to stories, and before they know it, their tenant is way behind. So this is not an unusual scenario. So $8,160 in the ledger. If this was presented to me, I would ask the landlord, I would say, all right, I need to see your lease because I need to see if the May late fee is deemed additional rent. And if it's not, I'm going to tell the landlord to do a new 3-day notice and remove the late fee. So it's very important that you check the terms of your lease to make sure that those amounts can be added. And I always say, if you're ever in doubt as to whether you can include it, just go with rent only. Okay, if the rent is $1,000 a month or $1,600 a month, and you're just not sure, your ledger has some miscellaneous fees, and you're just not sure, just add up the rent because you can't go wrong. Go rent only. Once you start adding additional fees, you could run into trouble. Another example. We have a Section 8 tenant, and for those of you who don't know, Section 8 tenants, they get subsidized housing. So, for example, if rent is $1,500 a month, Section 8 might say we'll pay $1,000, and the tenant is responsible for $500 out of that. So in this example, it's a Section 8 tenant. Monthly rent is $1,483, and the tenant's portion is $788. Tenant is behind by 1 month, and the ledger shows the following entries: $48 in water sewer bill backs, $606.53 for May rent. So we have a total of $654.53 in the ledger. So if the landlord presented this to me, I would consult the lease just to make sure that the water and sewer bill backs are deemed additional rent. And this is Section 8. So they're going to get a free lawyer from legal aid, and their lawyer will attack everything. So if the water sewer bill backs are included and they should not be included, it will be attacked and your case might be dismissed. Okay, and then the tenant might deposit the money in the register, which they're required to do, and because it's such a relatively small amount, and then you're definitely going to end up in front of the judge. So it's just very important to do your 3-day notices correctly. Okay. Now, any questions so far? That is it for terminating tenancies based on non-payment of rent. Any questions?
I don't see any questions at this time, but I have one. I have heard investors say that instead of doing a late fee, they discount the rent if it's on time. I guess that might be a strategy in order to just incorporate the total amount on a 3-day notice. What are your thoughts on that?
They discount the rent? Give me an example.
So if they say on the lease that the rent is, $1,000 a month, but if it's paid on the first, that the tenant will only owe $950.
Oh,
so they are showing that as a discount, but I think it's maybe a strategy for if there was a 3-day notice, then the total amount due would be the $1,000.
Yeah. It's really $1,000, and if it's not paid on time, then that $50 is kind of forfeited. It's not. Yeah, it's really just a tactic to force people to pay their rent on time. But whatever is written in the terms of the lease that it's $1,000, that's what would go on the 3-day notice. Because if the tenant didn't pay it on time and now you're doing a 3-day notice, then that $50 discount does not apply. You wouldn't be doing an eviction or giving a 3-day notice if they had paid on time. But yeah, it is not really consequential to doing an eviction. But thank you. Any others? Okay. So now we're going to talk about terminating month-to-month tenancies. And this is where, I'll tell you how month-to-month tenancies are formed in Florida. It's also called an at-will tenancy, and you might see this in other states. It's called at-will tenancies. And this is where there's no written agreement. And it could be there was no written agreement from inception. Two guys just happen to be having a drink, meet each other, says, hey, I got an apartment, it's empty, you want to live there? And they agree, they shake hands, and then the guy who rents pays his rent, the landlord collects it, and the tenancy is established. No written agreement, and it happens all the time. The other method is where the the lease expires and the landlord says, I'm not going to do a new lease, and, it's a mutual agreement, or the landlord accepts rent on the 13th month and he establishes a landlord-tenant relationship, a month-to-month landlord-tenant relationship going forward. So that's the two ways that they're created. So how do you terminate such a tenancy? Well, all you need to do is give a 15-day notice in Florida. There's one exception, which is Miami Beach, which requires a 30-day notice. But you give a 15-day notice, and I'm going to show you how to calculate it. It's not just a 15-day notice at your whim just because you don't like the tenant. So today is the 5th, and you decide that, I don't like the tenant, I'm going to count 15 days, and I'm going to have them out. That's not how it works. So what you need to do is give 15 days before the end of the rental period. And what does that mean? If rent is due on the 1st of every month, that notice must expire on the 30th or the 31st, whichever month you happen to be in, and you count 15 days backwards to make sure that you have 15 days before the next rent is due. That's how you need to think of it. Do I have 15 days before the next rent is due from this moment? And if you do, then your notice is going to be valid. If you do not, then your notice will be invalid. And the defense for terminating month-to-month tenancies is retaliation. So keep that in mind. Tenant reports you to code. You decide, I don't like this tenant. He reported me to code. I'm going to terminate his month-to-month tenancy. That is a big problem. If you have legitimate reasons and the tenant still had reported you to code, I would advise you to fix the code issues before you give that 30 days, so you take away that defense from them. So here's an example. There was never a lease. Rent is due on August 1st. Tenant pays rent but is chronically late and does not get along with other residents. Landlord can serve a termination notice no later than August 16th. And here is why. Remember, I told you it needs to expire before the next rent is due. So remember, rent is due on the 1st, so it would be September 1st. So if it's the 16th of the month and the landlord's saying, you know what, I'm fed up with this tenant, day 1 would be on the 17th, and day 15 would be the 31st. Remember, it expires the day before rent is due. If the landlord served it on the 17th, and day 1 is the 18th, then you don't have 15 days left in the month. So this would be a defective notice. You have to have 15 days left before rent is due, and it must expire the day before rent is due. Another example, lease expired a month ago. Parties never renewed, but landlord accepted rent. Under the lease, rent was due on the 15th day of every month. The notice must be served on July 30th and will expire on August 14th. See the pattern here? Rent is due on the 15th, so the notice has to expire on the 14th. Here's an example. Notice expires on the 14th. The last day to serve it was the 30th. When you count those days, you get 15 days. Now, the question is, can we serve it earlier? Yes, you can. You could serve a notice. In the example for August, you could serve the notice on August 1st, but what's going to happen? The tenant's not going to pay you, and that's what happens 99% of the time. The landlord terminates the month-to-month tenancy. The landlord terminates it too early, and the tenant says, well, you're kicking me out. Why should I pay you? The tenant is wrong. They're obligated to pay you the rent, especially if you don't have a last month's rent in your possession. They're obligated to pay it, but it's human psychology. You're kicking me out. I'm going to need this money to pay a deposit on another apartment, so I'm not paying you. So it's best to wait until you collect your rent and then you serve the notice. Okay. Any questions before I move on to another type of eviction?
Nope.
Yeah.
No questions at this time, but I just want to remind everybody, get your questions typed into the chat box as we go so we can get them answered. Thanks,
Okay.
Conrad.
Thank you. And yes, these are calendar days. It's only the 3-day notices that require you to skip weekends and holidays. So terminating month to month is calendar days. It can expire on Sundays, legal holidays, doesn't matter. Now, terminating for breach of lease. When we talk about terminating for non-payment of rent, the burden is on the landlord, on the tenant to prove that they paid the rent. You know, landlord says you didn't pay, tenant needs to prove to the court, I paid, and the landlord is wrong. When you're terminating month-to-month tenancies, the tenant can state that the landlord is retaliating, but that is the tenant's burden. The burden is on the tenant to win that case. Not so with terminating for breach of lease. You're saying that this tenant has breached the contract, so the burden is on the landlord. The landlord has to prove this case and win it. So if you can avoid terminating for breach of lease, you know, if you want to do it for terminating month-to-month tenancies or, you know, 3-day notice, I would recommend you go that route versus terminating for breach of lease. But I'll go into the rules with you. You need to give a 7-day notice to cure. Okay, on some rare instances, you can terminate immediately, but Florida law requires that if it's a curable issue, then you need to give the tenant an opportunity to cure. What's considered curable? Unwanted guests, unauthorized pets. You imagine it. If it can be fixed by the tenant, you have to give them that 7-day notice to cure. When is it not curable? Maybe it's a criminal activity, assault, battery, some kind of crime where the tenant is arrested, they're in jail. There's really nothing to cure at that point. Those matters cannot be fixed. Another thing you need to do when you serve your 7-day notice to cure is you need to avoid self-help. So the example is water. Tenant doesn't pay water. Your lease says, you know, let's imagine that you have a duplex. It's 1 meter, so it's easier for the landlord to pay the water and the tenant reimburses the landlord. Tenant doesn't pay, landlord gets upset, landlord disconnects the water. That is self-help. It's illegal in Florida, and you can be liable for up to 3 months of rent for each instance. Same with power. Maybe you're responsible for the power, and maybe you didn't even directly disconnect the power or the utilities. Maybe you just let it lapse. You know, the water is too much, or the tenant's doing this on purpose. He's running the water, and now my bill is huge. I'm just not going to pay that. Wrong. You have to pay it because that would be considered self-help. It's indirect disconnection of utilities, and it's treated the same way as if you showed up to the property and turned the water off. It is treated the same way. So you need to make sure that you either have the tenants sign in the lease that they're responsible for putting utilities in their name, or you need to make sure that you have enough funds to pay just in case the tenant is not paying. So talking about notices to cure, as I said, it can be used for many things. A lot of times it's used for unauthorized pets. It's used for unauthorized occupants, unsanitary conditions, and yes, that's real. This is from the archives of Kelly and Grant. Or, well, that's a writ of possession gone bad, but you get the idea what it can be used for. So the first thing you have to do is serve a 7-day notice with the opportunity to cure. Okay, and here's how you do this. I prefer to write these for my clients because I can go through the lease, and I can write this the way I know that it should be phrased. But I can teach you how to do it. So this is the secret sauce. If you're going to do a 7-day notice to cure, you need to cite the section in the lease that a tenant is violating, explain how they're violating the lease, and detail what they need to do to cure it. So think about it this way. Make it very clear. I'm show you an example shortly, and I'll give you some pointers on how to make it effective. If the tenants fail to cure, the only way to enforce a 7-day notice is to file an eviction. So if you say you have unauthorized dogs, there are 3 dogs, you're supposed to have 0, and you serve a 7-day notice to cure and the tenant does not cure, what do you think happens next? What happens next is you have to file an eviction against them, or you can let it slide, and then you'll be viewed as a weak landlord. This landlord, he gives notices, but he does nothing. So if you are a serious landlord or a serious property manager, if you're going to serve that 7-day notice, you need to be prepared to follow through with it. What are the things you need to do? Remember, the burden is on you to win this case. So what are the things that you need to do? You need to get your documentation. So in the example before, the landlord took pictures of those dogs because the landlord went over to fix the air conditioning, and the landlord saw that there were 3 dogs in the property. So the landlord was able to win that case. So you want to make sure that you take photos, videos, of the pets, the cars, the mattresses. If it's unauthorized occupants and one bedroom and there are mattresses everywhere, mess, loud behavior, this is a person who's disturbing other tenants. You also should get copies of police reports or public records such as code violations caused by the tenant, and get your witnesses ready, affidavits for court, your neighbors who are willing to testify, other property managers. You need to gather all this evidence, because when it's time for the trial, you need to win your case. You need to present all the evidence to the court, because the tenant can just sit back and say, this is a lie, I didn't do it. I had a case once where the tenant had a dog, and the judge said, do you have a dog? And she said, no, Your Honor, I don't have a dog. I've never had one. And then the landlord produced the pictures with the dog. Well, it was actually more circumstantial. It was a bowl and a bone, and it was obvious from the pictures that there was a dog there. And then the tenant said, oh yeah, I was just watching my brother's dog. But the judge at that point did not believe her, because he just thought she was lying to him. But the point is, even that was good evidence. Even though he did not see the dog, there was evidence of a dog. And there were several pictures which showed that the dog was in the property over a period of time. So that's what you need to do. So here's a 7-day notice to cure. This is the way it looks. We'll have it addressed to the tenant. We'll make sure it's dated. And then I used 3 different examples in this one to give you an idea of things you can include in your 7-day notice. Number 1. You have not changed your air conditioning filter, which is your responsibility under paragraph 10 of your lease agreement. That's weak, because it's supposed to be material non-compliance. It's weak. Some people might disagree with me and say not changing your filter can lead to the air conditioning failing, but you're going to have to prove that. And the tenant's going to say, I change my air conditioning every month. In fact, I change it every 2 weeks because I have allergies and I need to do that. So that's what's going to happen. Number 2, you have unreasonably withheld consent and access for the landlord to enter the premises by changing the locks and by failing to make yourself available for the landlord to enter and make repairs. Now this one seems important. Paragraph 15 of the lease and Florida Statutes Chapter 83 lists circumstances under which the landlord may enter the premises. Please provide keys to the landlord and agree upon a date in which the landlord may enter the property. I think this is important. I think this is material noncompliance, because having a lock, if there's an emergency, the landlord needs to enter the property. And apparently repairs need to be done. And this is probably something that the tenant reported to the landlord, and now the tenant is not giving access. So I think this is an important one. And remember, this is how we're going to apply my tip for creating 3-day notice. You have unreasonably withheld consent. You're stating what the problem is. Then you're going to support the problem. You're going to say paragraph 15 of your lease, or Florida statutes, whatever you want to put, but it's usually going to be your lease. Paragraph 15 of your lease tells you you can't do this, and then you tell them what they need to do to cure it. So it's 3 steps. Here's number 3. You've made unauthorized alterations without first obtaining the landlord's written consent. What is that? You're stating the problem. Then you state that paragraph 17 of the lease clearly states that you cannot alter the premises without the permission of the landlord. So you've supported it. You have altered the premises by changing the locks. We could have added anything. We could have said by changing the locks, by building a tiki hut, by building an above-ground pool, whatever it is, you could have stated that. but you're stating what the issue is and what they need to do to fix that issue. And that's your recipe for a good 7-day notice. But it's defective if you don't have this last paragraph. Demand is hereby given to you that you remedy the noncompliance in writing within 7 days, or your lease shall be deemed terminated, and you shall vacate the premises upon such termination if this same conduct or conduct of a similar nature is repeated within 12 months. Your tenancy is subject to termination without you being given an opportunity to cure the noncompliance. So you need to include that in your 7-day notices. This is directly from the statute, and this is what gives you the right or the grounds to evict that tenant without giving another notice. In the past, you had to give another notice. You had to give a notice of termination, but now you don't have to do that as long as you have this paragraph. And then you do your certificate of service, which is at the bottom, and once you do that, then you're set. And you can use this notice to file your eviction. Tenant change the locks. These are some examples that will help you understand this a bit better. Tenant change the locks and refuse to allow the landlord to enter the premises. Landlord needs to inspect the premises to make necessary repairs, but tenant refuses to cooperate. Landlord must serve a notice to cure, and if tenant fails to cure, landlord can start eviction. See, all roads lead to eviction. Example 2, tenant has frequent loud guests for late night parties. Landlord has never witnessed this, but has heard the complaints from several tenants. Landlord should serve a notice to cure, and remember, I stated here, landlord has never witnessed this, so the landlord needs to gather evidence, whether it's going to be a video or pictures, or the landlord's going to, show up at this party and pretend to be, one of the, an invited guest and take pictures, but it's necessary because the tenant's going to say, I only had one party and it was my birthday, and I'm sorry, and the judge is not going to evict them. Example 3, tenant punched another tenant and threatened to kill him with a knife. There's a police report. Landlord may serve a notice of termination. Remember, 99.9% of the time you need to cure. Here's one of the 1%ers. This is where a crime has been committed. And at that point, you can terminate that tenancy by serving a 7-day notice of termination. Question so far on terminating? No?
No, there's no questions so far, but you're doing a great job. Thank you so much, Conrad.
Thank you. I appreciate that. All right. So here's the eviction process in Florida. Okay? Keep in mind, Florida only. So people always want to know the time frame. It's an emergency. Even for the guy who didn't collect rent for 5 months, it was an emergency. I need this guy out of my property now. You can't. You have to follow the law. So the time frame is 4 weeks if it's uncontested, and this is an average. Our firm has done about 15,000 evictions over the years, and this is the average. It averages at about 4 weeks. Some counties are longer and some are shorter. Add 2 weeks if it's contested. So I'll talk to you about what contested means in a bit. Steps in the uncontested eviction. This is where a tenant does not file an answer. You deliver a 3-day notice or any notice. You file an eviction in county court. The process server goes to the property, serves the tenant with a 5-day summons. We wait 5 days. As soon as that tenant is served, the clock starts ticking. On the 6th day, we file a motion for default. We submit the paperwork to the judge, the final judgment, and so on, and the judge takes about 10 days to enter a final judgment. So this is the judge's part. Remember, judges have all kinds of cases. They're doing trials, criminal trials, civil trials. One judge told me that he had over 1,000 evictions sitting on his desk. So on average, they take 10 business days to enter a final judgment. It's not very long. If any of you have lived in other states, it's not really that long. Then, once the final judgment is entered, the writ of possession is issued and it is sent to the sheriff. The sheriff then, based on their own schedule, no one else's, goes to the property, posts a 24-hour notice. It's not really 24 hours. It means no less than 24 hours. days later or maybe a week, 2 weeks later, depending on the county, they will call the property manager or the landlord and they'll say, meet me at the property on Wednesday at 10 a.m., don't tell the tenant anything, and then they will show up and complete the eviction. The sheriff's part can take 7 to 14 days. Some counties it will be 7, and your really bad counties like Miami-Dade, it's going to take 14 days or more. It's been getting longer in Miami. So that is the process. I see a question here. It says, can a tenant say that, for instance, pictures were taken illegally because you crashed a party? He can say it, but the good news about county court is that the judges are very informal because this process is so quick. So it's not like regular court where I have to admit evidence and establish a foundation for the evidence. A lot of times the judge will just ask the questions. And if the landlord says, well, I have some pictures, because the tenant's going to say, I've never had any parties at my house. And the landlord's going to say, well, that's a lie, Your Honor. I have pictures of the party. And the judge's going to say, show me. And you just show the judge, and that's how it goes 90% of the time. So even if the tenant says it was illegally taken, it doesn't mean the tenant's not going to be evicted. The tenant might have some other cause of action. I don't know what that is. But the bottom line is the judge is going to enter a final judgment. The judge is going to say, tenant, you're a liar. I'm entering a final judgment, and you're getting evicted. So it's not going to help their case. You just make sure you have your proof. Now, if it's a judge that follows all the rules, just like, it's a regular lawsuit, then it would be, if the tenant said they didn't have a party, then I could attack their credibility, and then I could admit those pictures as evidence. And if it's a party, chances are it's a public party. Maybe it's outside by a pool, rather than inside. So anyone can take pictures of anything these days. All right, good question. So what if the tenant answers? If the tenant answers, then it becomes a contested eviction, all right? Contested eviction, and it takes some more time. So if you're a property manager, if you're filing eviction, some people do this, or you're a landlord with an LLC, at some point, if a tenant files an answer, you're going to need a lawyer to take that over. But if the tenant answers, if we're handling your case, the tenant answers, the judge can do one of 4 things. The judge can order rent into the court's registry. So an example of that, the tenant says, Your Honor, I know I owe the money, but I fell on hard times. And the judge is going to say, well, you admitted it, so you owe $2,000, put it in the court's registry. If the tenant puts the money in the registry, then the judge might order mediation. The judge might say, I'm going to let these people talk about it. Then if the tenant says in their answer, I think the rent amount is wrong. Now, I want to take you back to where you didn't consult your ledger and your lease, and you may have put the wrong amount. Then the tenant's going to say, this looks wrong. Where does 63 cents come from? My rent is $1,000 a month, and this says I owe $2,500.63. And they might ask for the judge to determine the amount of rent, and the judge will order it by law. Or the judge might order a final hearing and just, basically a trial, and just work everything out at that time. Depending on the county and the judge, we have to do additional motions. Some judges are proactive, and they will just order things and enter final judgments. And in some counties, things will just sit there for a long time, and you have to push it forward. I see a question that says, what does complete the eviction mean? That the tenant's belongings are removed from the property. We're going to talk about that in a bit. It's part of it. That's the writ of possession section. In fact, let me just address it now, just in case, since I boiled this down for you. So completing the eviction, let me back up. Yeah, just in case, I think I may have, I need to address this right here. So good question. So the question is, what does complete the eviction mean? So when the sheriff comes to the property, the sheriff will say, I'm going to meet you at the property Wednesday, 10 a.m. You show up. I usually tell the clients, make sure that you have your locksmith and you have some movers. So while the tenant is there, you can remove everything from the property while the sheriff is there. In the presence of the sheriff, you can remove everything from the property and put it at the curb or the designated place for garbage pickup. All right? And you're protected. The statute protects you from liability if you get the sheriff and you do the writ of possession. So I always advise getting the sheriff unless the tenant moved out and said, I'm out of the property and here's my proof. I recommend that you get the writ of possession to protect you from liability. And you can throw anything out. You can throw an expensive TV, a couch. It doesn't matter because the law protects you. So good question. Thank you. Who should use an attorney? I'm just going to gloss over this a little bit. If it's a corporation, keep in mind that a corporation is considered to be a person, and only lawyers can represent people in Florida. So corporations need an attorney. If you're not sure what you're doing, just get an attorney because it can be very serious business. Landlords lose all the time, and they're usually liable for a lot of rent, especially if legal aid takes the case over. So just keep that in mind. Suing for damages. A lot of people ask me this, and we're close to the end here. A lot of people ask about suing for damages, and I'll tell them, listen, if a tenant can't pay the rent to keep a roof over their heads, why would they care about your money damages? You know, that's just going to be a waste of your time and a waste of money, attorney's fees, especially if you use an attorney to do it. But if you decide to do it, determine if the tenant is collectible. Does the tenant have a job with a paycheck? Do they have assets, which if you win the case, you can seize the assets? Do you have copies of checks from their bank account so you can garnish? And what can you sue for? You can sue for your eviction costs, past due rent, time it took to re-rent the property, damages exceeding security deposit, attorney's fees, unpaid utilities, and so on. The only problem with this is you have to get personal service. If you can't find the tenant, it's going to take a while. But I usually tell landlords just move on. You know, it's part of the business, part of the game. Just move on, re-rent the property as quickly as possible, make a claim on the deposit to cover some of your losses, and just re-rent it. It's just not worth it. If a person cannot pay rent, you're not going to get any money out of them. Another question, could you have a charity such as Goodwill there while the sheriff is there and just donate the items? Absolutely not. Don't take anything. It's a good question, and that's why I'm so emphatic about it. It is not yours to give away. The only thing you can do is put it by the curb. Then it becomes public property. That's the only thing you're authorized to do. You can't take it. You can't give it away. It doesn't matter. It is the tenant's personal property still. So if you don't remember anything else I tell you is never take any of the tenant's stuff, ever, ever. Okay? I've seen landlords do that, and it's gone. It's not gone their way. Security
Conrad,
deposit.
before you go on, I had an additional question to that. What if you move it out and you put it to the curb? I mean, how long does it have to sit there before you can have somebody come remove it? What if the tenant just is, gone, missing in action? They're not coming back for their items, or they take what they want, but they don't take it all. What can you do then?
So this is going to be, I get this question a lot. So remember that every city has some kind of pickup schedule or bulk pickup or something along those lines. So it is really public property. There's lots of case law, not just on evictions, that says when something is moved to the curb, it's public property at that point. So it truly isn't your responsibility. But yes, I'm cognizant of the homeowners associations who will say there's something sitting on the curb. The statute doesn't give any guidance on that. I think it can sit there. I would be proactive, though. I would be proactive, and I'd make calls to the city about their bulk pickup and let them know there's something there to be picked up, just so you don't get fined. But it is not outlined in the statute, and it's going to vary by municipalities and homeowners associations and so on. So sorry I didn't have a definitive answer, but it is what it is. Any others? security deposits, and I'll tell you the quick rules on security deposits, and we're going to wrap this up. For security deposits, if you're returning the deposit, model tenant, you're returning the deposit, do it in 15 days. Why? Because this is what the law says. You don't have to remember anything else. If you're returning the entire deposit, 15 days. On the other hand, if you're keeping the deposit or some of it, so if you're keeping the deposit or some of the deposit, you have 30 days to return it. It must be sent by certified mail. You have to do a notice of intent to retain deposit, and you must send it certified mail, not FedEx, not anything else. Why certified? Because it's written in the statute, word for word, certified mail. And then the tenant has 15 days to object in writing. And if the tenant does not object after the 15 days, you can claim the deposit. If they object, another story. There might be a lawsuit, but it's a completely different matter, and we can talk about that if you're ever in that situation. And final slide, wrapping this up. Summarize, I would suggest you have a landlord-friendly lease. Don't include grace periods. A lot of people love doing them. You don't have to do it, because when you give your 3-day notice, are you not giving a grace period at that point? I think you are. Be very diligent and consistent in posting your 3-day notice as soon as rent is considered late, especially if you manage multiple units. Allowing tenants to fall behind in 1 month will cause them to be late in the next. So you will have this pattern that goes on and on. You accept rent on the 20th, they're not going to have it on the 1st. So you're not doing anyone any favors at that point. Although it may seem counterintuitive, it's best to file evictions rapidly. Don't listen to stories and excuses. Happens all the time. Some of these tenants are masters at weaving tales. So I would advise you to get hard proof. If someone was out of a job, you can work with people, don't get me wrong, but just make sure you get concrete proof, all right? Pay stubs and so on. Remember, they talk to each other, so if you have a duplex or a multi-unit, tenants will talk to each other, and they will say, hey, this is what I did to get out of that situation, so keep that in mind. And remember, the tenant still has an option to pay back rent and eviction fees by using stipulations, and I'll touch on that just for a second. Basically, once you file an eviction, you can settle a case at any time. You can enter into an agreement, and you outline the terms. The tenant's going to pay you all your fees, pay rent on time, and once they do that, then the court has the power to enforce the terms of the agreement. I believe that's it. Yes, that's it. A question here. Would this be something that you put on the lease? If your items are left on the curb due to eviction after 10 days, it will be given to Goodwill. It just seems it would be awkward. So you wouldn't put that in your lease because you can't give it to Goodwill. So, or did I read this question? No. Yeah, you can't give it to Goodwill. You can't. Don't put those things in your lease. This is not. It's the law you're following. It's not a game or just something you're making up along the way. This is the law, and the law just states the only thing that protects a landlord from liability is when the sheriff is there and the landlord is then authorized to put the items at the curb, and that's the end of it. The landlord's obligation to that tenant has ended. The landlord's liability is non-existent at that point. It's ended. So if you're in the business of feeling sorry and thinking about goodwill and so on, then it's a wrong business, because you might sometimes have to just be cold about it. Okay? You just need to follow the law. I've been in court many times where landlords took something or gave it away, and the tenant was so upset, and the judge is so upset and said that is civil theft. So just end with putting it at the curb. Can you put the security deposit slide back up? Okay. There it is. If you're keeping it, return it in 15 days, in 30 days, and if you're returning it, just return it as quickly as you can within 15. All right, that's pretty much it. If you have any questions, I would suggest that you you email them to Larissa and she can send them on to me. In fact, she can give you my contact info and you just reach out to me directly. I have no problem answering your questions. If you feel like I didn't answer something today, please reach out to me. Larissa?
Yes, absolutely. And Conrad is a great resource to you as investors. Definitely keep that in mind. His contact information is here on the slide. You can also email me at any time, and I can forward you over to Conrad. So thank you so much, Conrad, for joining us. That was a lot of really great information. If you guys want to hear the presentation again, I did record it, and we will share the recording on YouTube, and also you will get the direct link through email in just a couple of days. So thank you so much again, Conrad, and we hope to have you on again soon.
All right. Thank you very much.